Hi, this is Celeste, and this is Wait, is that legal? A podcast that comes from my own curiosity about the legal questions raised in TV shows and movies to determine what would or should have happened in the real world. So join me, a real lawyer, as I try to offer legal advice to fictional characters in fictional scenarios using real laws. This podcast is not intended to offer real legal advice to real people in real legal situations. It is just for fun. Before I start today's episode, I just wanted to give a heads up for potential spoilers. This episode will discuss plot points from the first and second seasons of Outer Banks. If you haven't seen the show and want to see the show, then you should probably watch the show and then listen to this episode. But if you haven't seen the show and you don't care, then you should still be able to enjoy this episode. It's summer. You and your friends are out of school for the next few months, and you've got nothing to do but hang out and solve the disappearance of your friend's parent, who was on the hunt for the treasure at the center of a local legend. Unbeknownst to you, the treasure is real, and your friend's parent made some serious progress in finding it, but was working with some shady partners. So, now your whole summer has turned into a fight for you and your friend's lives, and a fight to recover the treasure that could change all of your lives. This is the situation that John B. and his friends find themselves in the Netflix show Outer Banks. The show follows 4 teenagers who live full-time on North Carolina's Outer Banks, a place that during the summer is also filled with rich seasonal residents. The main character, John B., is still holding out hope that his father, who disappeared at sea several months ago, is still alive. John B. finds evidence that his dad made a big discovery before he disappeared. At stake is the location of the legendary shipwreck of the Royal Merchant, and the treasure it was rumored to be transporting. Of course, John B. and his friends manage to find all of the above, but end up with none of it by the end of Season 2. So, what happens when you find a shipwreck, or come across buried treasure, or find a priceless religious relic? Who would have the right to claim any of those things? And would the finder of the treasure get to keep it? If you find treasure but someone else steals it from under you, what rights do you have then? Well, let's find out on today's episode. So, there are a few different types of finds involved in the Outer Banks. So, I've divided it up into 3 exhibits. Exhibit 1, the shipwreck. Exhibit 2, the gold. And Exhibit 3, the cross. I will discuss the first exhibit in this episode, and then I've split up Exhibits B and C in a second episode. Exhibit A, the shipwreck. According to the show's local legend, the Royal Merchant was a British ship that was lost at sea off the Outer Banks after successfully raiding a Spanish treasure ship. John B.'s dad has spent his life searching for the fabled shipwreck, and correctly figures out that everyone had been looking for it in the wrong direction. However, he does not have the money needed to test his theory, and goes to Ward Cameron for capital. Ward is a successful businessman with a summer house on the island, and is the father of John B.'s later love interest. Interestingly, while the Royal Merchant is entirely fictional, there was actually a British ship called the Merchant Royal that was lost near Land's End off the coast of England in 1641. It has also never been found, despite treasure hunters and salvage companies searching for the wreck. The Merchant Royal was transporting about 100,000 pounds of gold, 400 bars of silver, and 500,000 coins. Its estimated worth in today's money is just over $1.5 billion. If found, it would be one of the most valuable wrecks ever discovered. So, in giving the fictional wreck in the show a very similar name, The show writers obviously wanted to convey some of the mystery and grandeur of the real Merchant Royal. Finding an abandoned shipwreck filled with treasure has featured heavily in a lot of fiction, and incredibly, even the non-fiction accounts of treasure hunters can sometimes be just as fanciful. However, most of the modern-day drama of treasure hunting plays out in court battles, as multi-million-dollar salvage firms apply for permits to search wrecks and to fight off claims made by potential owners and others with claims to the contents of the wreck. It is because of the high-stakes nature of the marine salvage industry and the potential historical significance of some of these shipwrecks that there are many laws, treaties, and international agreements in place. So, as it turns out, the shipwreck is actually one of the easier legal questions to answer. The setting of the show and the real Outer Banks are in North Carolina, and the shipwreck is supposedly within U.S. territorial waters. Both the United States and North Carolina have laws governing the discovery and salvaging of shipwrecks off their coasts. The Abandoned Shipwreck Act of 1987 gives the U.S. government ownership title to all abandoned shipwrecks within 3 nautical miles of U.S. coastline and in any internal waterways. The federal government maintains title to shipwrecks in solely federal waters, but title to shipwrecks on submerged land belonging to states or Indian tribes is transferred to the appropriate government entity. Before the 1988 enactment of the Abandoned Shipwreck Act, and for shipwrecks that lie outside of U.S. water, admiralty law generally applies. The U.S. also maintains title and exclusive jurisdiction over all U.S. naval vessels, wherever they sink, which is consistent with international and federal law. International law generally recognizes wrecked military vessels as the exclusive property of their country of origin, regardless of the waters they sink in. The U.S. also has multiple treaties with individual countries recognizing the sovereign immunity of naval shipwrecks and their contents. It might be worth taking a little bit of a detour here to discuss some of the maritime terms that I've been using. First, let's talk about how national boundaries within the ocean are established and defined. Historically, a country's territorial waters were all of their internal waters and the coastal waters that they were able to defend from the coast. This is where the 3 nautical miles comes from in the Act, because 3 nautical miles was how far a cannon could typically be shot. A nautical mile is equal to 1.15 miles, or 1,852 meters. The nautical mile is also equal to 1 minute of Earth's latitude, which is why it's such a weird number. In modern international law, territorial waters are all the waters controlled by a sovereign state. They include internal waters and coastal waters. Internal waters like rivers and lakes, and the water between islands in countries like the Philippines, are under the complete jurisdiction of the country they are contained within. Coastal waters are determined by the distance between the baseline, which is the low water mark on the coast, out to sea. The United Nations Convention on the Law of the Sea defines a country's territorial seas as the area from the baseline out 12 nautical miles, which is approximately 14 miles. The territorial seas are controlled by the country they belong to, and are considered sovereign territory, but the innocent passage of vessels through these waters must be allowed. From the baseline to 24 nautical miles is a country's contiguous zone. This area is a bit more flexible, because it might overlap with countries that are closer together. In this zone, travel is not restricted, but the country it belongs to can police the waters for various reasons, like immigration, environmental regulation, and economic regulation. The area from the baseline to a maximum of 200 nautical miles is considered a country's exclusive economic zone. The country that owns the economic zone has exclusive rights to fishing, drilling, mining, and other economic uses. The ocean that extends beyond the claimed economic zone is international waters, or the high seas. The recovery of property from the ocean under admiralty law is divided into 2 categories: the law of fines, and the law of salvage. The law of fines supports the rights of finders of abandoned shipwrecks. The law of salvage applies to ships that are still owned, but are wrecked or in distress. People who come across a ship in distress and offer aid are generally entitled to compensation. This rule was designed to encourage ships to come to the aid of other ships in distress on the high seas, because the likelihood of another ship passing when you are in distress is very low. Someone who salvages an owned shipwreck is usually entitled to either compensation for their services or a percentage of the salvaged goods. The U.S. Supreme Court has a 3-part requirement to determine if a salvage reward is owed. These requirements are 1. Whether the ship and its artifacts are in marine peril, which the fact that any shipwreck is underwater and subject to corrosion and currents is enough to constitute marine peril. 2. That the salvor's services are voluntary, so they're not under contract from the owners or the insurance company. And 3. That the salvage yielded results. If a salvage operation meets those 3 requirements, then the Supreme Court applies the 7-factor Blackwall-Columbus America test to determine the amount of the reward. To break this all down, let's look at some examples of shipwrecks where Admiralty law was applied by U.S. courts. The easiest of these is an Italian ship that was salvaged by an American man in 1993. The ship, the Andrea Doria, sank in 1956 and was in a known location and easily accessible. But the ship's owners never made any attempt to salvage it. The Andrea Doria is a very straightforward case, because it was privately owned and sank in U.S. waters near Nantucket Island. Almost immediately after the ship sank, divers actually began exploring the wreck and taking souvenirs. The insurance company that took ownership of the Andrea Doria never filed to stop people from gaining access to the wreck and never attempted to salvage the wreck themselves. As a result, when an American, John Moyer, applied for salvage rights with the Federal Admiralty Court in 1993, the court determined that the ship had been abandoned by its owners, so the law of fines applied, and he was awarded ownership of the expensive Italian mosaics on the wreck. Another example is La Belle, one of several ships used by the French explorer Robert Cavelier La Salle in order to establish a French colony at the mouth of the Mississippi River. The ship sank within Texas state waters and was claimed, along with its artifacts, by Texas. The state of Texas argued that the ship was abandoned because La Belle was given to La Salle as a gift from the French King Louis XIV, which would make La Salle's heirs the true owners, and they had not asserted a claim to the wreck. France argued that the ship was not abandoned because they were the true owners of La Belle. French records show that the ship was loaned to La Salle by Louis XIV, making it the property of the French government. International Admiralty law supports France's claim to the ship, so it could not be considered abandoned. Despite La Belle being found in U.S. waters, it was not abandoned, so that means that the Abandoned Shipwreck Act would not apply. France could have claimed law of salvage in an Admiralty court, but in the end the dispute was handled diplomatically. The U.S. government negotiated a deal between France and Texas that gave legal title of La Belle and her artifacts to the French government, and allowed the Texas State Historical Commission to have day-to-day control for 99 years. The ship is currently on display at the Bullock Museum in Austin, Texas. Admiralty law becomes increasingly hard to apply the more parties there are claiming both ownership and rewards. One muddied example is the extensive litigation surrounding the aptly nicknamed Ship of Gold. The SS Central America was a steamship carrying passengers and gold en route from the California Gold Rush. It serviced the second part of the journey, sailing from Panama to New York City. It sank during a hurricane off the coast of the Carolinas in 1857. At the time, it was estimated that $1.2 million in 1857 currency in gold was on board the Central America when it sank. The wreck was discovered in 1989 by Thomas G. Thompson and Columbus America Discovery Group, or CADG. CADG obtained the salvage rights and brought up approximately $400 million in gold. Several insurance companies claimed they had ownership in the Central America, but CADG claimed that they had sole ownership of the salvage rights. 1 decade and 5 cases later, the parties finally sorted out a settlement. One of the main issues brought up in the cases was whether the law of fines or the law of salvage should be used to determine the ownership of the Central America. Initially, the trial court used the law of fines, which gave CADG complete ownership of the wreck. The Fourth Circuit Court disagreed with the lower court's argument that the insurance companies abandoned their claim to the Central America because all the original documentation was destroyed. There was no evidence that the documents had been intentionally destroyed, and the companies just couldn't find a lot of them, which is to be expected after over a century had passed. The Fourth Circuit further explained that the law of salvage should be the default for maritime discoveries, because salvage law allows for more openness and cooperation than the law of fines, which generally favors an all-or-nothing approach. Using the law of salvage, CADG was eventually awarded 90% of the recovered gold, with the remaining 10% going to the insurers. In 2016, the court appointed successors in interest to CADG's salvage rights to the Central America Recovery Limited Partnership, was awarded 100% of the further $48.2 million in gold and artifacts brought up from the wreck. While the Admiralty case over ownership continued, Thompson was sued in 2005 by the salvage crew and his investors because they had never received their share of the gold. Thompson disappeared with the gold and had to be tracked down by the U.S. Marshals, who had a warrant for his arrest. Thompson was found to be in criminal and civil contempt of court for failing to cooperate when asked where the gold was. His civil contempt penalty is to remain in jail with a $1,000 a day fine until he gives up the whereabouts of the gold owed to his crew and investors. His criminal contempt of court punishment is 2 years in prison that he'll serve when he gets out after his civil contempt is resolved. Currently, Thompson has served almost 7 years and owes over $2.5 million in fines. Also, as part of a civil judgment against Thompson and CADG, Recovery Limited Partnership was given the salvage rights to the Central America. But seriously, guys, this case is so wild. It just goes on for decades, and there's so many parties involved, and Thompson is just filing motions all the time from jail. It's crazy. And this shows just how badly things can go when there's millions of dollars on the line and someone doesn't want to play by the rules. In contrast, there are stories of how things can go right. Take the Nuestra Señora de Atocha, for example. In 1622, a Spanish treasure fleet was sunk in a hurricane off the Florida Keys. Some of the ships survived the storm, and a couple were even salvaged by Spain in the years after the disaster. But the galleon carrying the majority of the fleet's gold and emeralds, the Atocha, was lost. In 1971, Mel Fisher and Treasure Salvors, Inc. found the wreck, which was estimated to be carrying $250 million to $500 million worth of gold, silver, and emeralds. Initially, the state of Florida claimed ownership of the wreck and awarded Treasure Salvors a 75% salvage reward. But after the case reached the Supreme Court, it was determined the wreck was not located in Florida's territorial waters, and that the law of fines should apply. Fisher and his partners ended up with the entire amount salvaged, and anything that might remain in the wreck. The Atocha is a lot older than the Central America, so Fisher did not have to contend with insurance companies making claims of ownership. the age of the wreck and the fact that the Spanish salvaged some of the ships in the fleet also lends weight to the argument that it is abandoned. This case was also decided prior to the passing of the Abandoned Shipwrecked Act, which might have made a difference, but probably wouldn't, because the Atocha was determined to be in international waters, which would put it outside of the United States' jurisdiction. When it comes to salvaging shipwrecks, the major difference between the U.S. federal law and Admiralty law is that Admiralty law is only really concerned with the commercial value of lost cargo. The Abandoned Shipwreck Act removes shipwrecks from the jurisdiction of Admiralty courts, which allows them to be classified as more than just commercial property. This is especially important when the historical significance of the wreck is larger than any material wealth that it may contain. So, because of the Act, the U.S. government can ensure that shipwrecks with historical value are preserved either by a federal agency or by the state or tribal authority with jurisdiction over the location of the wreck. According to North Carolina law, any shipwrecks which are unclaimed for more than 10 years and lie within the state's navigable waters are subject to the exclusive control and dominion of the state of North Carolina. North Carolina's navigable waters are defined as being within 1 marine league from the extreme low water mark of the Atlantic seashore out seaward. A marine league is equal to 3 nautical miles, or approximately 3.5 miles. The state designates its Department of Natural and Cultural Resources as the custodian of all shipwrecks the state has title to, and it is the department that makes the rules regarding the preservation, protection, recovery, or salvaging of the ships themselves and any property contained within. The state also requires that any exploration, recovery, or salvage operations be done by a qualified entity who must apply for a permit from the department. In the show, the coordinates on the map John B. and his friends find in his dad's office puts the Royal Merchant at 34 degrees, 57 minutes, 30 seconds north, and 75 degrees, 55 minutes, 42 seconds west, which, when put into Google Maps, is about 8 to 8.5 miles off of Ocracoke Island, North Carolina, which would put it well outside of North Carolina territorial waters. However, I'm not really sure what the extreme low water mark of Ocracoke Island is, and I did find some territorial maps for state territorial waters through NOAA, which is the National Oceanic and Atmospheric Administration, but those maps were clearly not meant for my level of maritime map expertise, which is 0. This doesn't matter though. In a real-world scenario, you would hire an expert, or rely on the state to determine where exactly the ship was and in whose jurisdiction. The Royal Merchant is a fictional shipwreck, and I think that the show was implying that it was close enough to the Outer Banks to be considered within North Carolina waters. In order to secure any claim to the shipwreck and to stay out of legal trouble, John B. and his friends should have applied for a permit from the North Carolina Department of Natural and Cultural Resources, or the DNCR. The department would then have been able to determine whether the Royal Merchant was in state waters and what the next steps would be. John B. and his friends are all also under the age of 18, so it would be likely that they would need an adult to represent them. Actually, throughout this whole show, John B. would have greatly benefited from having a lawyer, or just telling Sheriff Peterkin the whole situation that he was in from the beginning. There were a few adults in the show that probably would have been able to help John B. and his friends, though. The museum would have been a good place to start, or the teacher that helped John B. translate Tanny's letter, and then later gives Pope Tanny's journal. Even Pope's dad or Kiara's parents would have been able to advocate for the teens, and had both the resources and the community standing to possibly go up against Lord Cameron. Regardless, applying for a permit to search for the shipwreck and confirming the find with the North Carolina DNCR is actually not a total relinquishment of any rights or potential monetary gain. For example, in 1998, Intersal Inc., a marine exploration and recovery corporation, entered into an agreement with the North Carolina DNCR after they discovered the wreck of the Queen Anne's Revenge, which is the famous pirate Blackbeard's flagship. The agreement secured the corporation's involvement in all aspects of the department's activities involving the Queen Anne's Revenge, and gave them exclusive marketing, media, replication, and merchandising rights over the ship and any artifacts discovered by the state. In exchange for those rights, Intersal relinquished the salvage rights and possession of the physical contents of the ship. The state did claw back some of the media rights in a later Supreme Court case, but the example of the Queen Anne's Revenge shows that the discoverers of important shipwrecks do have some leverage to make a deal with the government. It also shows that it is possible to both reap the glory and wealth of discovering a significant treasure, but to also allow it to be studied and preserved for the good of everyone. While there is considerable value in the physical artifacts of a ship and the replicas and images that can be made from them, the biggest boon for the discoverer of a well-known ship is actually in the publication rights. An example is the discovery of the Civil War-era Confederate submarine, the CSS H.L. Hundley, which is considered the first successful combat submarine in history. On February 17, 1864, in a Confederate effort to break the Union naval blockade of Charleston Harbor, South Carolina, the Hundley successfully sank the U.S.S. Housatonic, and then disappeared. It was finally found in 1995 by author Clive Cussler and his NUMA organization, which is named for the fictional government agency at the center of many of his novels. The location and historical importance of the Hundley meant that the U.S. government took ownership of the wreck before transferring it to a commission formed by the South Carolina government, Friends of the Hundley. In 2000, the submarine was raised and is now on display at the Friends of the Hundley Museum in Charleston, South Carolina. NUMA spent 15 years searching for the Hundley and could not, and likely did not expect to, recoup the costs through salvaging. But Cussler was ultimately credited with the find. Cussler wrote a non-fiction book, The Sea Hunters: True Adventures with Famous Shipwrecks, which has a part dedicated to the Hundley. There is also a documentary show based on the book and several television specials about the Hundley that all mention Cussler. It also seems that the museum's gift shop sells Clive Cussler's novels. The bragging rights of being the one to find the Hundley was apparently valuable enough that there was a long court battle between Cussler and a man who claimed to have discovered the Hundley in 1970, but the case was eventually dropped. The National Park Service, the U.S. Navy, and the Friends of the Hundley all credit Cussler and NUMA with finding the submarine. The fact that a bunch of teenagers were able to find a legendary shipwreck, and the story behind that find, make this a compelling fictional story, so it would make a really good non-fiction story too. And even the slightly less exciting finds of the Hundley and the Titanic, at least less exciting in terms of treasure on board, both spawned profitable books and documentaries. Registering the find in order to profit from the story later is always a good move, and will secure any bragging rights for the find in the future. The fact that the gold had been removed already from the Royal Merchant was actually a blessing in disguise for John B. and his friends. The Abandoned Shipwreck Act makes the Royal Merchant government property, so any cargo found in or around the wreck would also be the property of the U.S. government, potentially transferred to North Carolina. Taking the gold from the ship would be stealing government property, which in the worst case scenario is a serious crime, and in the best case scenario would just result in forfeiture of the gold. It could also land them in some serious financial trouble, as the owners of Odyssey Marine Exploration Incorporated discovered when they salvaged millions of dollars worth of coins and other artifacts from a wreck found off the Iberian coast. In 2006, Odyssey was surveying the seafloor near the coast of Gibraltar when they found the remains of a wrecked ship. Odyssey's Black Swan project was initially believed to be looking for the aforementioned Merchant Royal, but the ship they found near the Iberian Peninsula was the Nuestra Senora de las Mercedes. The Mercedes was a Spanish Navy ship sunk off the Iberian coast by the British Navy in 1804. At the time it sank, it was carrying gold, silver, and various spices that it was taking to Spain from Uruguay. Odyssey filed their claim to the Mercedes in U.S. federal court in Florida, based on the law of fines and the location of the ship in international waters. However, it is notable that Odyssey filed the claim after they had already recovered $600 million worth of coins and other artifacts from the wreck, which they had already shipped and stored in Florida. Spain and Peru also asserted claims to the shipwreck and the cargo. Spain argued that the ship was a Spanish naval ship and was subject to sovereign immunity. Peru claimed that the cargo aboard the Mercedes originated in Peru and was produced by the people of Peru. However, Peru's claim was not entertained by the court because the court determined that they did not have jurisdiction to hear that case. The court ordered Odyssey to return everything that they had taken from the ship back to the Spanish government. The court also ordered Odyssey to pay $1 million to Spain for legal costs because Odyssey had acted unfairly and in bad faith, because they had kept the identity of the ship secret and salvaged and shipped the artifacts before filing a claim to the treasure. So not only did Odyssey lose out on $600 million in treasure, they still paid the cost of salvaging the Mercedes and shipping the coins back to the U.S. Then they had to pay their own legal costs, $1 million of Spain's legal costs, and the cost of shipping all the treasure back to Spain. And Spain now is displaying a lot of that treasure in its own museums. For John B., the stakes would never have been this high. He is not at the head of a multi-million-dollar corporate salvage company, and as such has neither the capital involved nor the expertise that the court cites as being why they penalized Odyssey. So, based on the examples that I've given above, how would the Royal Merchant be classified, and who would have the best claim for salvage rights? The Royal Merchant was a British merchant ship. We can assume it was not a naval vessel because there was no mention of Captain Limbury or Denmark Tanny having any rank or connection to the British Navy. So unlike the Mercedes, where Spain had a sovereign immunity claim to the wreck, the UK does not have a claim to the Royal Merchant. Also, under the federal regulations for the Abandoned Shipwrecked Act, it is specifically stated that even if the cargo is entitled to sovereign immunity, this does not apply if the cargo had been unlawfully captured by that nation. In this case, the gold and the cross were taken in an act of piracy, so the United Kingdom would not be able to claim any ownership even if the Royal Merchant was a naval vessel. With no legitimate claim by the UK to sovereign immunity, the Royal Merchant is an abandoned shipwreck. The shipwreck is located within U.S. territorial waters, so it would fall under the jurisdiction of the Abandoned Shipwrecked Act, with control going to either the U.S. federal government or to the state of North Carolina. However, the government nor John B. can do anything until the shipwreck has been registered. John B. needs to register his dad's coordinates for the location of the Royal Merchant as soon as he can. Why? Well, first of all, it's the right thing to do, because of the historical importance of the shipwreck. From the show, we know that people have been searching for the ship, and finding it would be a big deal for the community. Secondly, registering the find does secure some of John B.'s rights, and would secure his father's legacy as being the one credited with the find. If there was anything of value found on the ship, and John B. had registered the find first, he would have the rights and the ability to negotiate with the state. And, more importantly, Ward Cameron would be entitled to nothing. John B. would also have the publishing rights to a story and the ability to credit his father with the discovery. Finally, if the gold had been on the ship when it was found, John B. would have been in a lot of trouble if he hadn't registered the wreck with the authorities. The position that John B. and his friends found themselves in by the end of the first season of the show is arguably one of the worst-case scenarios. They had discovered one of the most significant finds within the show's given shipwreck lore, but no one in the Outer Banks even knows that they found it. The teens also know the story behind the wreck, about Denmark Tanny and where Tanny stored the gold on the island. This is all information that they could have used to put themselves in a better position to bargain with the North Carolina DNCR, and would have made their claim to the discovery of the Royal Merchant and the gold more credible than Ward Cameron's. Instead, they ended up with nothing, and are considered juvenile delinquents by most of the Outer Banks. It's not too late, though, for them to register the find of the Royal Merchant, because no one has actually found it yet, and Ward Cameron never got the coordinates, and he has fled the country. At the very least, they should register the find with the state of North Carolina. This concludes part 1 of my exploration of the legal issues in the show Outer Banks. I'll be back next time with part 2, and the discussions about the terrestrial finds by John B. and the gang. Thank you for listening. This show is researched, written, and recorded by me, Celeste Young. None of the legal advice or opinions expressed in this episode are intended as specific or individualized legal advice. If you have questions or comments, please email them to waitisatlegal@gmail.com. Always follow the rules when searching for shipwrecks. It can be very expensive to try to dodge the government and the people that you were supposed to pay.